All right, Mr. Umeki, this is cause number CR 20-3.
You want to see a copy of the plea approved? I mean, the motion adjudicated.
I do. Perfect. That's what I said. All right, Mr. Umeki. You appeared before the court on January 28th of 2020. You pled guilty to the third-degree felony offense of tampering or fabricating with physical evidence. The court heard the evidence on that day, followed the plea agreement in your case, deferred a finding of guilt, placed you on community supervision for 3 years, and assessed a $1,000 fine. It was during that period of your community supervision that the state filed a motion to adjudicate and revoke. And in that motion, they've alleged 5 separate counts on ways they believe that you have violated. Have you had an opportunity to review that with your attorney, Mr. Wells?
Yes, Your Honor.
You feel like you've had enough time to talk with him about these allegations and have all your legal questions answered?
Yes, I do.
I see here today that the agreement that you've reached with the state is that you would plead true to all 5 counts as contained in the motion, and the state's recommending that the court accept your plea of true, continue you on community supervision with some modifications to include 6 months in the county jail with you receiving credit for 57 days with your time to run concurrent with your Dallas County cause number. Is that what you are asking the court to approve here today?
Yes, sir.
And Mr. Umeki, has anyone threatened you, forced you, pledged you, or pressured you to make you feel like you had to plead true to any of these 5 counts? Court will accept the defendant's plea of true to all 5 counts. Mr. Wells, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
All right, that will be admitted into the record. Anything further from the state, Mr. Woodwhite?
No, Your Honor.
From the defense?
No objection.
All right. Mr. Umeki, the court's going to find that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement you've reached with the state. Court will continue you on community supervision, order you to serve 180 days confinement in the county jail with credit for 57 days served between the dates of August 4th, 2022 to today's date, September 29th, 2022. The court will order your sentence to be run concurrent with the Dallas County cause number F2135056. All right, Mr. Umeki. You understand another violation, next stop is going to be prison.
Yes, sir.
You understand that? All right. All right, Mr. Umeki, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. And there's no judgment on these. Is that correct, Mr. Woodwhite? Okay. All right, Mr. Umeki, you have a seat, and then when you get processed out of the county jail, you'll need to report to your probation officer or speak with them today about your next steps.
Judge, if I may, he has a Dallas County hold.
So
He'll
over
go
there.
to there because he'll end up serving the rest of that time in Dallas County.
Okay. Well, whenever you do get released, you need to report to your probation officer immediately and let them know what's going on.
But if I may, it will expire while he's at the Dallas County jail. His probation will expire.
Oh,
So
it's just one unorthodox. Okay.
I'm sorry, it's just where we are.
And so he's on deferred. He's pleading true, so we're going to continue. So it's going to show that he successfully completed probation, but he's expiring while he's in custody. Okay. Well, what's done is done. All right, good luck to you. Thanks, sir. Well, that was, yeah, I did not realize that's what we were doing. So I thought we were continuing him on community supervision, meaning that he was going to do his time.
It's a positive deal. So it expires January 23rd or 28th, I forgot. And so the Dallas County case that he will now get, because they've had a hold on this whole time, he will go there, he'll get his 6 months there. And while he's serving that time, which this 6 months minus the 57 days, their 6 months will eat up the rest of his probationary period. So in other words, she didn't want to extend, she just wanted to.
She didn't want to revoke him.
No, well, this was in lieu of another way to revoke.
Okay, okay. All right, council, do we have anyone that's ready to go? Who's going to be our contested hearings today?
Judge, I believe we've got a bond hearing on Mr. Gerard and Mr. Gerard is regarding minutes. Or one more, let's see what the test period for
All right.
this size will be a long spot.
Are we ready to move forward on Mr. Gerard?
It's actually entitled.
Can you handle it though? We're on a pretty tight schedule. I need to be out of here by 4. Okay, Mr. Gerard. Here, I'm just gonna have him have a seat in the witness stand just to save you. I'll just have him sit there. Mr. Gerard, come all the way up here and just have a seat over there in that folding chair. This is just bond reduction, correct? All right, this is cause number CR 2267, State versus Robert Gerard, motion to reduce spill. Are you gonna be calling your client today, Mr. Schmidt, for the limited purposes of bond reduction? Mr. Gerard, if you will, sir, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, Mr. Gerard, just speak up loudly and clearly for me. Ms. Grisham here is going to be taking down what you have to say. So make sure that we're talking one at a time as the attorneys are asking questions. Let them finish. You'll give your answer and then they'll ask their next question. Okay? Go ahead, Mr. Schmidt.
This, state your name. And you currently, previously you were released on PR bond, the state, didn't file on that by 90 days, is that right? I don't have my notes, but you missed the court date, about a month and a half, so that's correct. When you missed that court date, you and I had been in communication at that time, right? At the point that you missed, you tell the court what caused you to miss that. Right. You have to go. Okay. And as far as paperwork concerned, that your mother ran back most of that stuff because yes. Okay. So how long after you missed that court did you take them out? Once you bond grant and at $100,000, able to post that money. You have any resources there that you submit that? Yes, I can say you just moved it. This bill. What do you want this bill? Okay. And how much is
I'm sorry, Mr. Gerard, I can't hear you.
$600.
600 a month.
And did you manage that money or just? So if the court were to reduce your bond to a lower amount, would you be able to secure your mother bond out?
Yes, sir. I just thought it was.
And about how much money do you think, you can make up on?
She said I had said that she felt.
2,000, so if we reduce, if the court reduce, say, 20,000, you think you can post that bond?
Yes.
In addition to that, at no point so far, since you've been around some of this time, you've never lost contact with me, correct?
No, sir.
And we've been in constant contact even the day that you were out of this. And the court is most concerned obviously about the nature of your car. You understand that if you were on your ongoing conditions, pre-trial release. Now, we discussed this in the confusion, but
Yes, but it's not a problem. Actually, obviously,
okay, are you clear on what that means, Dennis? And so ultimately, we were telling the court that use the bond, that you would make all your court hearings, and also that you would supply those conditions. Yes. Now, normally, your mother is the one who teaches you that. Is that right? Yes. And what is your mother's name? Sam? And she works?
she's a retired now.
Okay. What did she do?
She's a claim that's in for Social Security.
Is she working again?
Well, she was.
Okay. And are you aware that she's also been in frequent contact with you about the case?
Yes, sir. That's what she said. Y'all take some correspondence.
So ultimately, at the bottom of the day, you're in court because you said, and before we can correct that issue, you are going to take in custody, correct? Yes. And if the court would reinstate you, you are going to be asking to do that. This, and not be asking to reduce this to 1,000 for this. I'll pass this.
Mr. Woodwhite.
Mr. Martin, sure.
Interesting, Mr. Gerard, do you have any documentation as to your COVID diagnosis? No, sir. I would see that. I don't really have. I started out. So you didn't go to the doctor? No, sir. You were just ill. Yes, sir. And you told your attorney, Mr. Schmidt, that you got basically $2,000. Yes, sir.
Any further questions, Mr. Schmidt? I have a few questions. Mr. Gerard, did you contact Mr. Schmidt the day that you missed court to indicate to him that you were sick?
Yes, sir.
You did?
Yes, sir.
And when did you call him?
It was a little. It was that morning before.
And you never went to the doctor?
No, sir.
How do you know you had COVID?
I had caught it in here before, and I just figured it was COVID, because I couldn't get up and do it.
So you don't know that you had COVID,
I'm pretty sure I did.
but you don't know. You didn't go to the doctor and have a test, get any kind of diagnosis.
It'll be the fluid of COVID, but I'm pretty sure it's COVID.
All right, Mr. Schmidt, anything further? Mr. Woodwhite,
Pretty hard.
you an argument, Mr. Schmidt, go ahead. Mr. All right, court, in considering the testimony of Mr. Gerard is going to deny the motion to reduce bail. Court's going to maintain bail, as previously said, at 100,000. Mr. Gerard set for additional hearings at another time, is that correct? See, we're coming back on the 8th for pretrial. Any other issues we need to take up today? All right, thank you, Mr. Gerard. You can have a seat. You have anyone else that's ready?
Yeah. Mr. Estrada.
All right, Mr. Estrada, just stay right there. Where is Mr. Estrada? Okay, can you hear from there, sir? All right, this is cause number CR 240, State versus Matthew Estrada. Motion to revoke. Go ahead, Mr. Schmidt.
Just the meeting that we today, in this time we've been working on, Mr. Estrada, not in particular. A modification of his conditions, since safety confirmed that he's eligible, Mr. Estrada would like to set that off. Obviously, we didn't know that, so an hour ago. So if we could be set on Monday or Thursday, to do that, we can be ready to do that.
Will you be here on the 11th, Mr. Schmidt? All right, court will set Mr. Estrada for plea October 11th. That'll be at 1:30.
Brianna Rogers, so we got a similar same amount.
CR 21-236, State versus Brianna Rogers. Can you hear from there? All right, Mr. Schmidt has indicated to the court that Ms. Rogers, you want to enter a plea for safety. Is that correct?
No, sir. It's me, but
Oh, I thought you said the same announcement.
so that we said for the amount.
Okay. All right, court will find that Ms. Rogers has reached a plea with the state. Court will set that for entry October 11th at 1:30.
Judge on Benson Lane.
CR 07152, go ahead.
Judge, what's the word in the state on this training? I'd ask for an additional setting on this HER to give you more extension prior to proceeding to the hearing.
State.
Judge, take an agreement, Mr. Schmidt and I had a discussion, about his name appearing in the state's previous file, whether there's going to be objection back to that. We didn't have substantial discussion in, resolving this. We have come to the agreement that, Mr. Schmidt is going to continue representation on Mr. Freeney, but because of that, I didn't make an offer till today lunchtime, so.
That's correct, Judge. I do think that, I need to review with the state the file so that I can adequately relate Mr. Freeney what the level of my fault is. I believe I know it is. I don't know that you have an objection, but you just at least give it an opportunity to weigh in if necessary. If not, I'll just proceed.
Do you think we'll be able to have an answer? If I reset to October 27th, what I don't want to do is us get on the 27th and then Mr. Freeney say, I want a new lawyer, because then that's going to put us off another 60 days probably. And then Mr. Freeney will have been in 4 months on a motion to revoke.
So they'll like to resolve that issue at least within Mr. Freeney within the next few days, most likely. So I think that may be fine.
All right, court will set Mr. Freeney for motion to revoke or adjudicate October 27th. We got Mr. Powell,
I think that, there's,
the status.
Status. We are, waiting for Dr. Proctor. Finish his last examination of Mr. Powell. We still have the one to watch that we'd like to let ride until that's done. Also, the defense expert. He's not going to spend the court's money until we get the results, or at least the report. So from that perspective, I think, last public was very, we're both on the same page as far as proceeding for that.
Any conversations with Dr. Proctor on when he thinks he'll be done?
Well, Judge, directly from the, I do know that he was hoping for some additional records that might have stored on the camera. And I'm not certain, I think it was verified with someone that he was requesting jail records and some other stuff. So as far as the holdup, I haven't spoken to him since then.
State, do y'all know?
Judge, I'm unprepared to make an announcement as to the records. I do know Ms. Curry told me that Dr. Proctor report was not complete yet, and that she's waiting on that still. But I can't make an announcement as to whether he's waiting on us. My understanding is, to our knowledge, we've given him everything and we're waiting on his file report.
But it's plausible that he's waiting on y'all and y'all are waiting on him. And we don't move forward. Is there anyone that, does Ms. Curry have the knowledge to tell me whether whatever he's requested has been provided? Because I don't want to set it in perpetuity and then find out later that each one of them's waiting on the other.
I think he's probably, based on the last email I got. Maybe 72 hours ago, it was a reference to records.
But you said you don't have access to those
I
records.
know, later, previously. Well, you mentioned it, I'm not sure, but I will agree with it.
Well, have you asked the state for the records?
State wouldn't have either, what's the state, grand jury's been, they're gonna be.
Med records from the jail or somewhere else?
They couldn't find it. There's med records from some other inpatient facilities. Ultimately, could I get them? Yes. I don't have it now.
Yeah, you'd have to do a HIPAA release and subpoena and all that. If you could consult with Ms. Curry to find out if, I just want to know if there's something lacking that the state's got to produce before he can finalize. If it is the medical records, then you'll just need to know what that is. Let's see, you also have Robert Campbell, CR 19-108. Are you ready on that one or you want time on that one? Sure. Mr. Manning, are you ready on any?
Judge, we got 4 pages already, just taking the zero square. I don't know how I'm gonna do it. Are they allowed to, they're not with our own stuff?
As long as security is with me, yes. Or you can just bring them right there to you and then Ms. Cassell could step right there and just want to. Tomorrow at lunch.
And y'all wait for them.
We'll be in here all day. Tomorrow.
But I mean, you gotta take them.
Oh, at lunch, they're gonna clean. Like, they're gonna clean, like, like bring carpet cleaners in and doing that.
It's pretty like 10.
Is it gonna be dry? By the time we come, is it gonna be stinky chemicals and all that?
They said they had to wait until 5 and she said, no, I was a trade that. We have court all those things. What can they do with it? Lunch?
As long as it's not. You get strong chemical smell and wet, all that. I mean, because we got all our stuff sitting before. They can just, she's out today, right? Who's doing the cleaning?
It's a company.
Over it, I don't know. Keep on.
See if you can find out if it's, I mean, if it's just like a water and shampooing, that's fine, but just tell them I don't want no chemical smell as we're all in here. It's a small courtroom with poor air circulation. Yeah, it's really.
If all we're not, this is all, if we want to take out just your those days.
All right, cause number CR 21-185, State versus Mitchell Wade Ragland, motion to revoke.
This is, this is a case we set last, this hearing. I was speaking to my client, doing some research. I reached out to this, Ms. Patty, this, earlier this week, as to how to proceed. But the court wanted a full motion filed, or the court wanted to do that, so it's not that I haven't heard back yet. If the motion would like to be filed, I had one prepared from last time, I want to do it one year on.
State, any position?
Judge, I think upon some research of our own, the state position, on this previously discussed issue, is that the probation filed under purview of the district court. So we don't believe that there's a conflict, but obviously if Mr. Manning, feels the need to file that motion, we don't object to filing the motion, but our position would be that, that's not.
Now, I wish there was a bright line rule that would guide us on it, but there's not. So Mr. Manning, I'd say to go ahead and follow the motion to recuse, and I'll refer it to my presiding judge, and we'll let him maybe educate us on if there is a bright line rule that I'm unaware of as to.
And Judge, the question's been asked many times, in AG opinions, in court of appeals cases, but there is no right line rule. It seems to be taken on a case by case basis. There's no real clear guidance from the rule that I've been able to look at. So, I'll get that file today, and I assume we'll be hearing from the signing judge.
Yeah, let's go ahead and just keep it on the docket for 10/27. I'll do the, you follow the motion and I'll do the recusal referral immediately, and then we'll see who he assigns. And I'm sure that they may even be able to do that by Zoom.
Okay.
We'll make that available to them. It really depends on which judge gets assigned. You may.
And once again, don't know if I provided that to the state yet.
Ms. Peters, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. In your case, you've been appointed an attorney, Mr. Manning. Are you pleased with his representation of you? You feel like you've had enough time to discuss the case with him, have all of your legal questions answered?
Yeah.
And is there anything about this paperwork that you've read and signed today that you do not understand? Mr. Manning, do you believe Ms. Peters to be competent today?
She is,
And Ms. Peters, have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? Are you on medication for those? Do you feel like you have a rational understanding of the proceedings as they are occurring today? And Mr. Manning, is your client waiving indictment today?
she is.
All right, and Ms. Peters, do you understand that all felony cases in Texas enjoy the right to have the case presented to the grand jury and for the grand jury to review the evidence and decide if they believe that it's more likely than not that a crime was committed before the case can come to court and be prosecuted? Do you understand that?
Yes.
You also understand that you enjoy that right, but you can waive that right too. Has anyone threatened you, forced you, or pressured you to make you feel like you had to waive your right to an indictment today? And you're asking the court to allow the prosecution to proceed with their case based on what's known as an information, which is just a direct filing with the clerk. All right, court will find that Ms. Peters has waived her right to an indictment. Ms. Peters, it appears that you've been charged with the third-degree felony offense of possession of a controlled substance in penalty group 1 or 1B with an amount between 1 grams and 4 grams. A third-degree felony in the state of Texas does have a range of punishment of not less than 2 years in prison and not more than 10 years in prison, and a fine that may not exceed $10,000 if imposed. I see that the plea agreement in your case is that you would plead guilty to that charge in exchange for the state's recommendation that your sentence be assessed today at 6 years confinement in prison, a $2,500 fine, plus court costs, restitution, reimbursement fees. The DA's office appears to be dismissing resisting arrest or search or transport, burglary of vehicle, fraudulent use or possession of identifying information, and also a failed to ID fugitive, give false info. And you would also, pursuant to this plea, receive 73 days credit toward your sentence for the time that you've spent in jail. Is this the plea agreement as you understand it?
Yes, sir.
And that's what you want the court to approve today?
Yes, sir.
All right, so Ms. Peters, then I'm going to ask you, how do you plead to the third-degree felony offense of possession of a controlled substance?
Yes.
You pleading guilty to that crime, Ms. Peters, because you are guilty of committing that crime? Ms. Peters, has anyone threatened you, forced you, or pressured you to make you feel like you had to plead guilty today?
No.
All right, court accepts the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
So just state one.
All right, state's one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No.
From the defense?
That's a public good.
All right, court will review the evidence briefly. All right, the court has reviewed the evidence. I do find sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement in this case. The court hereby convicts Miss Christy Lee Peters of possession of a controlled substance in penalty group 1 or 1B, an amount of greater than or equal to 1 gram, less than 4 grams. Assesses her sentence at 6 years confinement in the Texas Department of Criminal Justice. Orders her to pay a $2,500 fine, $290 court cost, $180 restitution, and $15 in reimbursement fees. Court also awards Ms. Peters 73 days credit for the time that she has spent in jail on this cause towards her sentence, and the court will take into consideration under section 1245 the other offenses as indicated in the judgment. Ms. Peters, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you get fingerprinted with Deputy Everett here. It's here. Anyone else, Mr. Manning?
Yes, Judge, right on, Mr. Murph.
Mr. Murph, if you'll step up, CR 2060, State versus Colton Murph. All right, Mr. Murph, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got. All right, you can lower your hand. Mr. Murph, you appeared before the court on August 25th of 2020. You pled guilty to the offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams, a 3rd-degree felony. The court assessed your punishment on that day at 10 years confinement in the Texas Department of Criminal Justice. The court suspended that sentence and placed you on community supervision for 3 years. Court also ordered a $2,500 fine. During your period of community supervision, the state has filed its motion to revoke, and they have alleged in 6 separate counts, various ways that they believe you have violated your community supervision. Have you had enough time to review that with your attorney, Mr. Manning? You feel like you've had enough time to talk with him about that and have all your legal questions answered? And Mr. Manning, does Mr. Murph waive the formal reading of the state's motion to revoke?
He does.
And I see that part of the agreement is that the state's agreeing to abandon counts 1 and 4 on the motion. Is that correct?
That's correct, Judge. Count 1, that case was brought by Martin County in August, and count 5, Ms. Murph's family, in an effort to secure the video paid off. I think the majority, if not all, of probation due to
Count 4?
count into, which I think is count 4.
Yeah, count 4. Okay. All right, Mr. Murph. So at this time, I'm going to ask you, how do you plead to counts 2, 3, 5, and 6? Are those counts true or not true? Those are all true? And Mr. Murphy, are you telling me that those counts are true? Because in fact, they are true. You're not just telling me that so you can get a plea agreement? And Mr. Murphy, has anyone threatened, forced, or pressured you to plead true to any of these counts? All right, court will accept the defendant's pleas are true to these specific counts. Mr. Manning, any objection to the admission of the defendant's waiver of rights to plea of truth? That will be admitted into the record. Court will take judicial notice of Mr. Murph's judicial confession. Anything further from the state? From the defense? All right, based on the evidence presented to the court will approve the plea agreement today. Court finds that Mr. Colton Murph has violated the terms and conditions of his community supervision. The court finds counts 2, 3, 5, and 6 to be true. Court, pursuant to the plea agreement, revokes his community supervision, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations. The court will award Mr. Murph 89 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Murph, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Have you step forward to be fingerprinted? Log jam. You ready, Mr. Quintanilla?
That's great, Judge.
Mr. Quintanilla? All right, Mr. Quintanilla, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, thank you. You can lower your hand. Mr. Quintanilla, you appeared before the court on May 27th, 2021. You pled guilty to possession of a controlled substance, a state jail felony. Court heard the evidence, found that there was enough evidence to convict you on that date, but the court followed the plea agreement you reached with the state. The court deferred a finding of guilt, placed you on community supervision for 3 years, and ordered you to pay a $4,000 fine. During your community supervision, the state filed its motion to adjudicate and revoke. And in that motion, they alleged 11 separate counts of various violations. Have you had enough time to review that with your attorney, Mr. Manning? And do you feel like you've had enough time to discuss it with him and have all your legal questions answered? Are you pleased with Mr. Manning's representation of you? Mr. Manning, do you believe your client to be competent today to enter into an agreement?
Yeah, Judge.
And Mr. Manning, you've explained to him his rights as they pertain to this case.
Have it.
And does he waive the formal reading of the state's motion?
He does.
And is it his intent to be true to all counts?
That's correct.
All right, Mr. Quintanilla, I see the plea agreement is that you would plead true to all counts, state's recommending revocation plus 18 months confinement in state jail, with you receiving do you have any credit time? Or is- okay, I see that now. So it's 18 months, then suspended for you being placed on 3 years straight community supervision, with you paying your original fines, restitution, plus reimbursement fees for old attorney fees and new attorney fees. Is that your understanding of the plea agreement, Mr. Quintanilla? And Mr. Quintanilla, can you tell me what would be different this time if I put you on probation since the last time I put you on probation? Well, you better know a whole lot more than that. You gotta tell me, you need to convince me that I need to put you back on probation, because what I'm looking at says, don't do it, don't put him back on probation. It says that you possessing controlled substance.
If I may, he over in Coffee County has already taken responsibility for counts 1, 2, 3, 4. He has got sought help through the probation department versus with his drug issues. And we're going forward with this case in the hopes that he can now that he has even more serious charges hanging over his head, that he can get life back on path and could go this probation that way.
So what is he on papers for over there?
10 years.
10 years? For what charge?
I believe it was for
Firearm by felon? Or, I'm sorry, unlawful carry
it was possession.
possession? And so what help has he sought through the probation department? Is he going to rehab or is he?
Well, Judge, at this point, he's been, touch a coffin and so.
I mean, is he going to safety or anything through Kaufman?
No,
Well, I'm saying, what are the resources that he's utilizing in Kaufman County that are going to help him?
Judge, library, drug court, 2 specialized dockets. And my understanding was that the star. I don't know if he's got a drug court program, but he's getting called through the drug treatment program. In 4.2, I believe.
State, you think that Mr. Quintanilla is good candidate for continued probation?
Judge, state position is that the team is taking a longer probation on a higher charge. They're hopeful that he will complete. If he does, then he will be going to prison in Kaufman. Our intention to. I have the concerns that you have, but with our higher charge pending, I don't want to cause him to be revoked from his probation there, given our state jail less than 1 gram charge. Basically, the state's reason is that we are going to allow him the opportunity, with the understanding that if he messes up, our charge will not matter that much because of that's my rationalization for proposing this.
And here's my concern. As I sit here and I look at other inmates, it almost sends the message that you can be on a felony probation here and go get a higher felony charge in another county and then come back here and be on felony probation with little, I mean, there's I guess the punishment here is he goes from what, defer to straight.
Yes, sir.
So he picks up a conviction. Is he convicted in Kaufman County already? So that's my concern, is that there's no jail time as a condition, there's no back time taken. Let me think about this one. I'm not sure I'm gonna approve this one. Have a seat, Mr. Quintanilla, and I'll call you back up in a minute. Do you have any more, Mr. Moon?
Judge, I just have the,
You have the writ?
with,
You wanna do that one? Mr. Dennis, is that correct? Mr. Dennis, come on up. Are you gonna be calling your client to testify?
Judge, if I may speak to him. Judge.
Sure.
Yes, sir. He'll be calling us.
Okay, are you gonna call him first?
Yes, sir.
All right, Mr. Dennis, come on up here. Have a seat in this chair over here. All right, this is written number WR 2282. Writ seeking bail reduction. Mr. Dennis, if you raise your right hand, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got. All right, you can lower your hand. Go ahead, Mr. Manning.
Mr. Dennis. You were in jail for what charges? Okay, and you know what your bonds were set on those cases? Okay, and were you arrested on that? Were you arrested on a warrant or were you arrested on something? Okay, and what was the date of that arrest? Okay, and were you provided with a PC affidavit or probable cause determination in the jail? Did a magistrate come to you and make a probable cause determination or magistrate you on the charges? And are you able to make $150,000 bail? Do you have any assets? Do you have any land, home, vehicle? Okay, what happened to that vehicle? Okay, and do you have access to that vehicle? Does it have your title? Okay, do you know how much that vehicle is worth? Okay. What type of vehicle is it? Okay, is it good in good running order? Do you know how much value? Okay, you have a job? Okay, and do you have any savings? Okay. Do you have anybody that could assist you with $150,000 bond? Okay. Were you the sole provider for your family? Okay. How much did you have in month per rent? And did you also have dependents you were caring for? Okay. If the judge were to reduce your bond, something you can make, what would that amount be? And have you spoken to any bondsmen, in an effort to secure a bond on these cases? Yes, sir. Okay, and, have any of them been able to reach an agreement on any of them on the bonds that they're currently set? Okay, and, based on your conversation, if you are reduced to something in the range of 36,000, you believe you'll be able to make that bond based on your conversation to reduce that? There are some past.
State.
Mr. Dennis, so you were arrested August 28th, about a month ago, is that correct? And as your attorney asked you, you were arrested on these charges, but you were also arrested on a warrant of something, correct? You have a bond on that, is that correct? You understand, even if you got a bond, you guys go Smith. Judge, statement offer states exhibit 1, which is the affidavit.
Any objection?
This is the first open slide. I just had.
Sure.
No big.
All right, there being no objection, state's exhibit is admitted. What did you offer this as?
Spaces in one. Purpose, limited purpose of this area.
Go ahead, Mr. Levine. Mr. Manning?
No big reference.
All right, you can step down. You can come over here, Mr. Manning. Anything further from the defense?
Judge, I think with the offer of states one, as prima facie evidence that, there was a writ, hearing at some point within the 48 hours as required under 1732 for rest of the warrant. So at this point, we've abandoned that part of the request in our writ, but we're moving forward request for reasonable bond in this situation. Based on the finding, sorry, I'd ask the court to take tradition of the court file, based on the finding of the chain as well as testimony today. He's unable to move forward $100,000 bond. We request that it's be found unreasonable.
What is reasonable for Mr. Dennis?
Judge, I believe you can make a bond for the $30,000 based on resources, and his work, and his assets. I think that'd be reasonable for him to be able to take care of this business.
Did he testify that he had assets and ability to make 20 to 30,000, or was he just?
Basically, that's based on, we can recall it if you like, I believe that's based on his, being able to gather resources. As I said, he lived with his mother and brother, so I think that's the money we've been able to help us.
Right, state.
Judge, we would ask the bond be left as is, Mr. Davis was debating the right to get warrant. He had zero confidence that it will him on a core bond, that he will return to this person. That's what he did.
All right, court's gonna review the evidence briefly, the exhibit. All right, court's reviewed the evidence. The court's going to deny Mr. Dennis's request for a reduced bond at this time. that all you have, Mr. Manning?
Wait,
Mr. Quintanilla, all right. So I'm gonna stand in recess, meet with State and Mr. Schmidt. And then we'll meet on Mr. Quintanilla as well. All right, of course, we're gonna stand in recess. All right, we are back on the record. Mr. Schmitz, with regards to Mr. Campbell. Let's see here, this is CR 19-108. Court understands the arguments of counsel. The court appreciates that. However, I'm going to require additional information as it has been disclosed to you in chambers. Understand that you are strenuously opposed to what the court wants to do. However, I believe it's necessary for the administration of justice. So I'm going to reset Mr. Campbell until October 27th. Understanding that may not give you the time that you need, but we can lay status on that day if we don't have something else worked out. You want anything else on the record about that, Mr. Schmidt?
There's one of the things that we did not discuss, change about, what we tried for it. But only urge, candidates request. And ask the court to consider that, and then the hearing room.
All right, court will reconsider the motion for a PR bond. The court had previously I haven't denied that by written order, but the court was not considering it based on some of the violations alleged for Mr. Campbell failure to report to community supervision. I'll take that under advisement and I will reconsider it between now and October 27th. All right, Mr. Manning, Mr. Quintanilla, CR 2131. Mr. Quintanilla, the court is not going to accept your plea at this time. I want to take that under advisement. I've spoken to the state and Mr. Manning, your attorney, about my concerns. Mr. Manning, I believe that you're asking for additional time to try to calm the concerns of the court and determine other potential outcomes for Mr. Quintanilla. Is that right?
That's correct. That's 100%. I will speak to the state, include up to his docket, and we'll see if we can address the concerns of the court, but also be in the best interest of justice of our client. So we will present that on October 13th.
All right. Court set recess, Mr. Quintanilla, for status on the motion to adjudicate October 13th at 1:30. And I believe that concludes the afternoon docket. Is that correct, Steve?
That's correct, sir. That's all we have.
All right, court will be adjourned.
Thank you. Notice that we were discussing how,
I thought today was just on the motion to reduce bond, so I didn't go. Oh, I wrote that on the wrong one.
yeah, that's for here.
Yes, so we'll reset, Mr. Powell. Then you want that 10/27 date, or you want a little longer to deal with Dr. Proctor? Do we want to set it for we got an evidentiary on 11/29. I will put status 11/29 on Dr. Proctor. Thanks, sir. All right, now the court will stand adjourned.